Bonjour, chères étudiantes et étudiants. C'est le professeur Hazem Atlam. On reprend ensemble notre cours relatif au droit international pénal, International Criminal Law. Cependant, à raison du virus du corona, on le reprend à partir des cours à distance, comme vous le savez bien. J'espère que ça va finir bientôt et qu'on pourrait reprendre ensemble nos cours ici dans les enceintes de la faculté et que vous iriez toutes et tous très bien. Bien sûr, tout de suite, je vais reprendre mon cours en anglais, comme d'habitude. Parfois, je vais faire une petite traduction de l'anglais en français pour que ce soit plus clair pour vous. Et ainsi, on commence. Vous vous rappelez bien sûr, si l'ouvrage est entre vos mains, que à l'occasion du dernier cours, notre dernier cours ensemble, à la filière, on avait examiné le contenu qui se situe à partir de la page 57, je veux dire Universal Jurisdiction, the duty to prosecute and amnesty. On a examiné ces trois thèmes, Universal Jurisdiction, page 58, the duty to prosecute, 61 et suite, and obligation to prosecute and not to offer amnesties, page 65 et suite. Ensuite, on a examiné comment a été créée, c'est la page 70, comment a été créée la Cour pénale internationale, les tribunaux pénaux spéciaux provisoires, Yugoslavia Tribunal, page 71, Rwanda Tribunal, page 72, et c'était clos à partir d'ici. Donc, pour notre cours d'aujourd'hui, on va examiner à partir de la page 73, 74, le sujet se rapportant à la mise en œuvre par les institutions internes des États des clauses relatives au statut de la Cour pénale internationale. La mise en œuvre, ce qu'on appelle l'implementation. The implementation by the internal system of law of states of the statute of the International Criminal Court. In another signification, the implementation by the system of law of states of the criminalization of the international crimes of war, crimes against humanity, crimes of genocide, and crime of aggression. And crime of aggression. That is from page 73 till page 80. Till page 80. Then you will see that in page 80 we are here within a paragraph having the name, the German Code of Crime Against International Law. The German Code of Crimes Against International Law. From page 80 to page 89. From page 80 to page 89. This party, the German Code of Crimes Against International Law, from page 80 to page 89, is excluded from the exam. Is excluded from the exam. Will not be a part of the exam. Then we will examine today the implementation within the internal system of law of states of all crimes against international law which are stipulated by the Statute of Rome, creating the International Criminal Court. Then, from page 73 to page 80. From page 73 to page 80. That is the object of our course today. Why, if the International Criminal Court exists today and it is a permanent court having competence to judge all physical persons who are presumed, who are accused to commit an international crime between those stipulated in the statute of the International Criminal Court, I mean one of these four international crimes, crime of war, crimes against humanity, crimes of genocide, or the crime of aggression. Why it is important that this crime must be implemented, must be stipulated in the internal system law of states. That is the question. That is the question. If it is possible now, because of the existence of the International Criminal Court as permanent courts, to persecute the accused person, why it is requested, why we suppose that an obligation, an international obligation exists here relating to that each state must implement, must include these four international crimes in their legislation by indirect or direct incorporation. Indirect incorporation or direct incorporation within methods that we will examine today. Why? That is the question. That is the question. To give an answer to this question, we must examine how and when the International Criminal Court will have competence to prosecute the accused person in one of these cases of accused person to commit crimes of war, crimes against humanity, crimes of genocide, or a crime of aggression, within the stipulations of the International Criminal Court statutes. In fact, it is reiterated that the personal competence of the court against accused person is only a subsidiary competence, is only an exceptional competence. As a principle, two conditions are required: as to give the possibility for the International Criminal Court to examine one or the other of these crimes when attributed to physical person. The first condition relates to that it is required that this physical person hasn't been traduced to his internal system of law to be persecuted of committing one of these four international crimes. In this meaning, that the first institution having competence to examine the crime is not the International Criminal Court. It is the states having personal competence against the physical person accused to commit the crime. I mean, the state, the national state of the accused person, or the state in the territory of which this accused person has committed his crime. Then always, that is, the states, by their internal system of law, who has the first competence to judge this accused person, not the International Criminal Court. Not the International Criminal Court. Then, if a physical person is traduced to the International Criminal Court and no states having competence to examine this crime has been the first one to examine it, in this case, the International Criminal Court will not be competent to examine this case. The competence of the International Criminal Court is subsidiary one, not principal one. The second condition, I say that even if we are within a person, a physical person, who has not been traduced before the internal court of the competent state. In this case, also the International Criminal Court will not be able to examine this case unless he states as a principle is party to the statute of the International Criminal Court. Then two conditions required to give competence to the International Criminal Court. First one, that the competent states haven't examined the crime, haven't deferred the accused person before its national tribunals. The second condition, that even if these states haven't do so, to give competence to the International Criminal Court, it is required that this state who does not implement his competence to traduce this person before its tribunals must be party to the treaty creating the International Criminal Court. Why this second condition is required? In fact, this second condition is required because we have to understand how the International Criminal Court, when a state will not punish an accused person, how the International Criminal Court will be able, by which procedure the International Criminal Court will be able to examine the claim. In fact, this will be so if another state, also party to the treaty creating the International Criminal Court, will defer this physical person to the International Criminal Court. And a state party to the Treaty of Rome will not be able to traduce a foreigner or a national before the International Criminal Court unless his national state or the state is the territory of which he has committed his crime is also party to this treaty. We are here within a multilateral treaty producing its effect only between its party, only between its party. Then a state party to the Statute of Rome, supposing it is the state X, will not be able to traduce a physical person having the nationality of a state Y unless two conditions are existing and satisfied. The first one, that the state Y haven't traduced this physical person before its national tribunals. The second condition is that the state Y itself must be party to the treaty creating the ICC, the International Criminal Court. It is clear now. The competence of the ICC is exceptional. And it is required that the states must be party to the ICC treaty to give the ICC itself the possibility to judge the physical person supposed to commit international crimes. International crime. This obligation by the principles of public international law must be assumed by states to be party to this statute, as you know, by the courses you have had in the second year, within the topic of public international law. Each state is free to conclude or not to conclude a treaty. Each state is free to be party or not to be party to a treaty, a bilateral one, regional one, or multilateral one. Then no obligation for states to be party to the ICC treaty. Some states as France, England, Djibouti, Tunisia, Jordan are party to this treaty. Other states as Israel, US, or Egypt itself are not party to the Treaty of Rome. To the Treaty of Rome. Then the ICC will not be able to judge an Egyptian national because Egypt is not party to the Treaty of Rome itself. One exception exists here with regard to states who are not party to these statutes, as for giving the ICC the possibility to examine crimes against physical persons having the nationality of one of these states which are not party to the Statute of Rome. We will examine this exception later. That is in the case stipulated in the ICC statute, in the case where that is the Security Council by a resolution adopted within the Chapter 7 of the UN Charter, then within a positive vote of at least 9 of its 15 members, including all the 5 permanent members, decides to defer before the ICC a crime attributed to a physical person, even in the case where this state is not party to the ICC Treaty of Rome. Example, in the practice, in the international practice, the ex-president of Sudan, Omar Bashir, has been deferred before the ICC, despite the fact that Sudan is not party, and this was by a decision adopted by the Security Council. Also, the ex-president of Libya, Muammar Gaddafi, and also both of his 2 sons has been deferred before the ICC by a decision adopted by the Security Council, despite the fact that Libya is not party until now to the ICC statute. Then it appears from what I have said now that for states who are parties to the ICC treaty, and also for states who are not party to the ICC Treaty of Rome, both of these 2 categories of states, it is required that their legislation, that their national legislation recognize that these 4
لا اجيب لك ترش عليك انا شايل
Excuse me. Excuse me.
طيب أنا خلصت وحمشي. الله سلام عليك. محمد مش حمشي.
Then I say, excuse me, a colleague came now. Then I said now that the implementation of all these four categories of international crimes, crimes of war, crime against humanity, crimes of genocide, and the crime of aggression must be implemented in the national legislations of all states. 1. States who are party to the ICC. 2. By states who are not party to the ICC, because as a principle, in all cases, the ICC, to be competent to examine a crime, it is required, first of all, that the national states must, in instance, first of all, must be proved that the state haven't persecuted the accused person. The competence is recognized first of all to the national state. Being with the case of a state party or a state non-party to the ICC Treaty of Rome. A state party will not be able to traduce a national state of a statewide if this statewide, 1 is not party, 2 if this state haven't respected this obligation to traduce him before its national tribunals. Why the stipulations of the Treaty of Rome require that first of all it must be proved that the national state haven't traduced this accused person before its proper national tribunal, and why it is also required that this national state must be party to the Treaty of Rome to give the possibility in this case when the state doesn't traduce the accused person before its tribunal to give the possibility to the ICC to do so. In fact, that is the principle of the sovereignty of states. That is the principle of the sovereignty of states. 1, as I said, by international law, no obligation is assumed by state to be a party to international treaties. That is only facultative. Number two, having their sovereignty, all states, because detaining sovereignty, detain their personal and territorial competences in their state. First, it is their proper law who regulate all matter realized in their territory. Then, within a crime committed by a national of the state, that is the criminal law of this state will be applied to the crime relating to a crime committed against a foreigner established in his state. Also, that is this state who will have the competence to examine the crime committed against a foreigner established in her state. That is then the consequence of the principle of the sovereignty of states. No international tribunal may have competence to examine crimes committed by individuals unless, first of all, we give the possibility to these states to do so by their national law and by their national tribunals. The exclusive exception, I examine it, is when the Security Council, by a binding resolution adopted within the Chapter 7, defer a physical person before the ICC, despite the fact that his national state is not party to the Treaty of Rome. But here also within the condition that the ICC must prove that the national state hasn't exercised his principal competence to traduce him before his tribunals. The case of Omar Bashir, for example, ICC must prove, first of all, that Omar Bashir has not been introduced before national tribunals. And now, as may be you know, despite the fact that ICC traduced Omar Bashir before the ICC, now, when he has been destituted from his functions, he is now traduced before the ICC or before the Sudanese internal tribunals. He is now traduced before the Sudanese internal tribunals because we are here within the principal competence of national state to traduce individuals before their tribunals. Then, by this introduction, I can suppose that you understand the answer relating to why the implementation of the 4 international crimes referred to in the national system of law of state is required. That is the question that we have to examine today, and now we understand why this question is so important, why the implementation is so important. Before examining now how the implementation will be able to produce bi-national system of law of states, we have to give an answer to another question. The first one was why the implementation is important. The third question will be how the implementation will arise. The second question we can examine relates to so. Is the implementation constitute an obligation for state, yes or no? I've said that every state is free to be a party or not a party to an international treaty because he has his proper sovereignty. Yes? But state has yes or not the obligation to implement in their national legislation these international crimes, even if they are not party to the Treaty of Rome. That is another question. That is another question. States are free to conclude or not to conclude treaty. But they are free or not free to implement the international law, the international treaty in their national system of law. That is another question. And in fact, we are here with a principle recognized by international law. You have examined in second year within the course of public international law. What is this principle? Within the principles of public international law, a principle is established from the 18th century. And this principle requires that states state hasn't the right not to respect their international obligation by reclaiming that is their national law who require that from them. In another signification, states are not allowed not to respect their international obligation by pretending that is their national law who require them not to respect these international obligation. That is the principle relating to the introduction of the international obligations of states in their internal system of law. Then, even if a state is not party to the Treaty of Rome, because these international crimes constitute by themselves international obligation for states not to allow individuals to commit them, then here we are with an international obligation incumbing for all states in the purpose to introduce these international crimes in their internal system of law, to give the possibility for the international law to be implemented in their internal system. That is the answer relating to the second question. Why, even if a state is not party to the Treaty of Rome, has the obligation to implement the stipulation of the Treaty of Rome relating to these 4 crimes in his national system of law. Going to the third question. If the implementation is required, because the state has sovereignty, and if it is known that states has not the obligation to be party to the Statute of Rome, and even if they will be party, never the ICC will be competent unless the state's party have introduced the accused person before their internal court, and also for non-party state to the Treaty of Rome, the ICC will not be competent to examine the crime as a principle unless this crime is deferred by the Security Council. Then it is now established that for all the states, parties and not parties, the implementation of these crimes in their internal proper law constitute an obligation by the international law, because by the principles of international law, as I said, no state is allowed not to respect its international obligation by pretending that these international obligations are not considered as so by their internal system of law. Then by this method, we have now to examine the third point relating to how the implementation of these international crimes will be done by states. A question here, as by the stipulations of the ICC treaty, we have here a mechanism, one mechanism for this implementation required by the ICC treaty, as if the ICC treaty will stipulate that there is one mechanism, a mechanism X, Y, or Z, which must be this adopted by states in the purpose to this implementation? In fact, no. And never in a multilateral treaty, Treaty of Rome or another multilateral treaty, never this treaty will stipulate how, by which mechanism, the state will go to implement their disposition in their proper internal system of law. Why? Another time, because of the principle of equality in sovereignty between states. The obligation is assumed by state to implement these international crime in their proper system of internal law, but if they assume this obligation, they have all the right to assume it by the mechanism recognized in their internal system of law. Then, here, the implementation of this crime in the internal system of law will be done by the systems recognized in the constitutions and the legislations of each one of the states constituting the international community. And within this matter, if we compare the internal system of states regarding how, by which mechanism, the implementation of multilateral treaties is done in the proper system of law of states, we will go to the conclusion that no common mechanism exists here, because the stipulation of the constitutions of states are not the same regarding to these mechanisms. And here we refer to our course in the second year, the course relating to the introduction to international treaty in the internal system of law, where it has been recognized that we have in internal system of law two important schools. The first one, dualist state, and the second one, the many states. I mean, dualist states, the states who adopt the voluntarist school. Many states, I mean, states who adopt the objective school. We are within these two methods for incorporation, for implementation of the international treaty in the internal system of states. Dualist system, menaced system. How can we explain these two systems, dualist system and menaced system? By a comparative exam of the national system of state regarding the implementation, with our example here, the Treaty of Rome, in their system of law. In fact, within these two schools of the dualist theory in one hand and the menaced theory in the other hand, I can, and it is possible, to say that within these two methods, we are within one of two mechanisms in the dualist state and in the menaced state, one of two mechanisms for the implementation of these international crime in the national system of these states. One of two mechanisms. The first mechanism, by the first mechanism, we are within an indirect implementation, an indirect incorporation of these international crime in the internal system of the state. An indirect implementation or indirect incorporation. What I mean here by indirect, I mean that and this will be only for states who are party to the ICC treaty. Here, by a stipulation in the constitution of the states, by which it will be reiterated that the Treaty of Rome, within all its stipulation, constitute a part of the law of the state. Indirect incorporation. France, for example, is party to the ICC. By the Constitution of France, we have a stipulation by which treaties constitute a part of the system law of France. And then a legislation will be adopted here in direct incorporation. A legislation will be adopted after the ratification by France of this treaty of the ICC. A legislation will be adopted by which it will be said that the Treaty of Rome is a part of the system law of France, without copying the treaty, without adopting a legislation where all the stipulations of the Treaty of Rome are adopted. Only a legislation within two lanes by which it is said that the Treaty of Rome constitute a part of the system law of France. Also, other state party, Djibouti, Jordan, Tunisia, etc. The inconvenience here, if we adopt this indirect incorporation, that it will be possible that the tribunals will not be within knowledge that this legislation exists. The executive authority also. The legislation doesn't stipulate all the clauses of the treaty. Only it is said that the Treaty of Rome constitutes a part of the system law of the state. Then that is the indirect method, the indirect mechanism. In one hand, but in the other hand, we may be within system of law which adopts not an indirect system of incorporation, but a direct system of incorporation. A direct system of incorporation. And by this direct system of incorporation, all the stipulations of the Treaty of Rome will be adopted by the national system of the state. Within only one method or one of two methods? No. The answer, by one of two methods. The direct incorporation of the Treaty of Rome by a state party, because within the first methods, indirect incorporation, that is by a state party. Direct incorporation within one of two possibilities also for the states who becomes party to the Treaty of Rome. By one of two methods. The first one, by adopting a legislation which incorporate as so the Treaty of Rome in this legislation. Then a legislation, suppose legislation number 100, 2020, is adopted by the Parliament. And this legislation stipulates as so all the clauses of the ICC treaty. Then the ICC treaty is incorporated as so within all its clauses in the national system of the state as so, as it is. It is copied in another signification. Copied as so. Another mechanism of direct incorporation is supposed also. A state party to the Treaty of Rome, without copying as so the Treaty of Rome in a national legislation, adopt its clauses in its criminal law within stipulation adopted by the legislator, which will not be in their form as the stipulation of the Treaty of Rome, but in their essence they will be the same. Then, in one hand, indirect, in the other hand, direct. For the direct incorporation, first mechanism, by copying the treaty as so in a legislation, or by not copying it, but by exposing what it is recognized in the treaty by other formulation, by other formal formulation, by the legislation. The penal code of the state. the penal code of the state. In this case, the legislator will adopt a legislation which will be here to appear in the penal code of the state to add the crime which are stipulated in the ICC between the crimes recognized as so by the internal system of the state. Then by indirect incorporation or direct incorporation, here and there, it appears that states who will adopt indirect incorporation or states who will adopt direct incorporation will be only states who decide before to be party to the ICC treaty. Who decide first of all before to be party to the ICC treaty, to offer themselves the possibility to traduce physical person before their tribunals as a condition before that the ICC be competent to examine this crime. Conclusion. If we are within a state who is not party to the ICC treaty, as Egypt, for example, we can suppose that neither the indirect incorporation or the direct incorporation will be adopted, because in this case, Egypt, not being party to the ICC treaty, will not adopt an indirect incorporation by a legislation reiterating that the Treaty of Rome is part of the system law of Egypt, will not adopt also direct incorporation by copying the treaty as so in a legislation or by adding in the penal code of Egypt the four international crime. In this case, we will be with a state who, in one hand, is not subordinated for its national person accused to commit this international crime to be deferred this individual before the ICC, and in the same case by the national system of law of Egypt, this crime, because not stipulated in our penal code, will not be considered as crimes within the system of law of Egypt. Because if we examine our criminal system of law, only the crimes of war are considered as a crime within the Egyptian system of law. It is not so, neither for crimes of genocide, nor for crimes against humanity, nor for the crime of aggression. Then, if a physical person, a national of Egypt, or a foreigner established in Egypt, commits one of these crimes, crime of genocide against humanity or a crime of aggression, and it is supposed that these three crimes never will be committed unless the biggest authority of the state, president of the state, prime minister, minister of defense, give order to commit this crime, never this physical person will be traduced to the internal tribunal, because we are not here with an internal crime, and never also he will be traduced before the ICC, because Egypt is not party to the ICC treaty, which will not be, and then no possibility for other state party to defer this physical person, Egyptian one or foreigner one, committing one of these crimes in Egypt, no possibility for foreigner state to traduce him before the ICC, because Egypt is not party to the Treaty of Rome. And the ultimate exception, as I have said before, the possibility for the Security Council, in this case, to traduce the accused person by the stipulations of the ICC treaty. The Security Council, by a resolution adopted within the Chapter 7, binding resolution then, may traduce, but we require here a positive vote in the Security Council of at least positive vote, including all the permanent members, to traduce a physical person before the ICC. And as you can imagine, in the practice, the strategy of each one of the 5 permanent members will not be the same as yes or no we consent to traduce him to the ICC. One veto used by one of the permanent members will avoid that this physical person may be traduced before the ICC. We will be here by this recourse to the right of veto within a situation within which it will be impossible to traduce a physical person committing an international crime, in the case in which, in one hand, his national state is not party to the ICC treaty, and in the second hand, where the implementation, as I explained now, of this international crime in the national system of this state has been ignored in the 2 cases. Because in this case, because of the absence of a resolution by the ICC, because the absence of a resolution adopted by the Security Council, because it is not possible for foreigner party states to defer the claim because that the national state is not party to the Treaty of Rome, we will be with a case in which an accused person, maybe a person which have yet committed an international crime, will not be persecuted neither before national court nor before the ICC, and maybe in this case, as we have examined last course, the ultimate possibility will be realized if one or another of states which give themselves by their proper national legislation the right to persecute by the system of universal competence the right to prosecute this accused person. That is for today, relating to the implementation of the international crimes within the internal system of law, why it is important to realize this implementation, how to do so, and what will be the consequences if this implementation, and this will be in the case where we are not within reference by the Security Council to the ICC of a case. In this case, in this possibility, the difference before the ICC of a person accused to commit an international crime will not be possible because the state is not party to the ICC in one hand, and in the other hand hasn't incorporated by indirect way or direct way of this crime in his internal system of law. That is relating to the course of today, and as I have said now, from page 80 to 89 excluded from the exam, and then in the next course, next week, we will begin our exam of part 2, general principles, of international criminal law, general principles of international criminal law, I mean from page 90, till page, I suppose, till page 90 to page 106. Maybe you will have the possibility to exam from page 90 to page 106 or before. It will be next week, inshallah. Thank you.